Morning. Good morning. Welcome back. Welcome back. We had a nice Easter, a good Passover. Before we begin, my former student Kyrie has a brief announcement.
Hi, my name is Kyrie Cameron. I'm one of the co-chairs of Board of Advocates. I just wanted to stop by and tell you guys really quickly that on this Thursday at 4:45 in Garretttown, we're going to be having an informational meeting about the Summer Trial Academy. The Summer Trial Academy is the way for any of you who are interested in being a varsity mock advocate to get involved and to be on a team. The Summer Trial Academy is kind of the tryout process where you learn all the fundamentals of mock trial, and then you do a mini tournament during the summer, and then tryouts happen after that, and each makes his teams based on those results. So, if you guys are at all interested in doing mock trial for South Texas, it's one of the best experiences I've had here being an advocate. We would love for you to be there, and we don't want to take time to answer questions about mock trial or anything now while you need to hear from Professor Blackman, but we'll have lots of people at that meeting on Thursday to answer any questions that you have. So if you're at all interested, come by, ask a lot of questions, and we'd be happy to give you more information and tell you all the details. But we'd love to see you on Thursday. Thank you.
Thank you, Kyrie.
Thanks, Professor Blackman.
All right, welcome back, everyone. Hopefully, a nice break from me, at least, I suppose. All right, any questions? Anything lingering? Anything in your mind from last class? Yes, sir.
We were wondering whether the tiers of scrutiny are applied to the substantive, if it's just a simply substantive due process 14th Amendment argument without equal protection, do you apply the tier of scrutiny, or is that only applicable to equal protection arguments?
I'll do that in about 30 seconds. The answer is yes.
Okay.
I was actually going to lead off the class with that exact question, so I'm glad you asked it. See, you read my mind. What other things are in your mind? Yes, ma'am.
People see my chair.
I'm sorry, can you hear?
So I know this is a long way back, but for the three zones of authority in Jackson's dissent in Youngstown, are those called zones of executive authority or congressional?
I should call them zones of presidential power. You can call them whatever they want. They speak really of the relationship. So what her question was, remember the Steel seizure case, right? And Justice Jackson had this opinion asking, does Congress support what the president's doing or not? So it's asking how much power does a president have from Congress? So you can call whatever you want. Jackson didn't really call them, but he called them 3 tiers, 3 zones. Unfortunately, in law, there's always 3 of things: 3 scrutinies, 3, there's always 3s. I don't know why that happened. I think it's a law school thing. People love 3-factor tests, but that's how it works. I understand this is, that's why I'm getting the question, right? Yeah, I thought so. Okay, which is fine. What else is on your mind before I start? And Hector, I'm not dodging your question, but I will get to it in a minute. Okay, yes, ma'am.
Okay, I'm just trying to figure out how to say that Lochner test again.
Ah, Lochner,
And,
yes.
okay, I get it confused when you say too broad and too narrow. I get those. I kind of understand it, but I'm get confused on what's broad and what's narrow.
Okay, I'll answer your question after Hector's, okay? Because it's related.
Okay.
Anything else not on other topics? I promise I'll get to it. Just make 30 seconds. Okay. So the topic of scrutiny drives students nuts. And the reason why it drives them nuts is because you use the same word to mean different things in different contexts. Right? The same word, strict scrutiny, means one thing for equal protection and another thing for rational basis. The same word, rational basis, means, let's say it again. The same word, strict scrutiny, means different things for equal protection and due process. The same word, rational basis, means different things for due process and equal protection. You use the exact same terms that have different meanings, and this drives students batty. So last week in class, I put together a fairly good, I don't know if it's good, but a fairly concise summary. I'll let you judge if it's good or not. A fairly concise summary of how scrutiny works. And I want to run through this one more time. As I mentioned last time, this kind of analysis you should have drilled into your head as memory. You should not have to even think and look at your notes, right? So we have 2 types of scrutiny, and we have due process scrutiny. Okay. 3 tiers of scrutiny are basically applying to both categories of the 14th Amendment. So how do we know if we're talking about equal protection scrutiny? There's some sort of classification. Be classification on religion, on gender, on age, on race, on whatever. But some sort of classification based on a person's characteristics. Okay? How do we know if we're talking about what's sometimes called substantive due process, which is really what we're discussing here? Not procedural aspects of the law, but does the law have any substance, right? This is the example we gave of the lottery, where you had these really fair procedures of who got stoned to death, but the actual law itself was absolutely insane. Or if you want to look ahead to the Buck v. Bell case, you had a very fair procedure, and then you determined to cut them as fallopian tubes, right? So the actual substance of the law is what renders it violating. So while equal protection looks at classifications, scrutiny looks at rights or liberty interests, if you will. Is some law infringing on some sort of right or some sort of liberty interest? And this can be an easy one. You know, what if it's... Okay, then we have a case like Lochner. What if it's infringing on like an economic right or an economic liberty? What if we have a case like Griswold we're doing today? What if it's infringing on some sort of nebulous right to privacy, wherever that comes from? Okay. The first question you ask yourself is this government law classifying people based on some sort of characteristic? Or is it infringing on some sort of right or liberty interest that a person may have? Depending which path you take, you know, either talking about equal protection scrutiny, it's this terrible impulse of students to give me labels, which that will not serve you well. So, okay, so where does strict scrutiny apply? Well, what's the classification? Race, religion, nationality. If the government makes a classification based on race or religion or nationality, think Korematsu, think Brown v. Board of Education, right? Think Loving v. Virginia, where the government classifies people based on their race, we know that this is something that's very suspect. Okay, these are even called suspect classes. The reason why it's called a suspect class is because we're suspicious. Suspect, suspicious, right? We're suspicious when the government we have a classification that's based on race. This is a suspect classification. And we have our test. And again, and this is Connie's question, right? I want you to actually understand how these tests work. So I'll state the test and I'll explain it. Okay? Is the classification narrowly tailored to serve a compelling interest? Okay? The test is a classification narrowly tailored to serve a compelling governmental interest? Okay? And I use these words, means and ends. And you often hear the phrase, the ends justify the means, right? What does that mean? Are the steps we're using to get there suitable to where we need to go? So our end, right? Let's think of Brown v. Board of Education, right? Why did the government segregate the schools? Well, they said, if we have segregated schools, there'll be more peace and people will be, you know, they won't be fighting and all these other reasons, right? What was the mean to get there? Having segregated schools. What is the fit, right, between having a peaceful society and having segregated schools? Not very good. I'm pretty sure they can achieve a peaceful society without segregating schools. Not only that, we have these phrases, narrowly tailored and compelling governmental interests. What does it mean for something to be narrowly tailored? You are using race as little as possible, right? They are, you know, with Brown, they're having segregated schools, different schools. That is not narrowly tailoring. That's a very broad rule. In contrast, Michigan Law School, they use race in a very limited context, right? That is narrowly tailored, using race as one of many factors. So the essence of narrow tailoring is that, race is in there, just enough, but not too much. Okay? And what's this compelling governmental interest? It's such an important interest that government can't exist without it. National security in Korematsu. We need to stop, these Japanese Americans from bombing us, whatever, right? Affirmative action. Diversity, the benefits of diversity are so important that we need to be able to achieve this, and we can use a little bit of race, okay? Think of the affirmative action case as a guide, right? You can only use a little bit of race to achieve the very important goal of diversity and the benefits therefrom. That is something that will survive strict scrutiny. And really, that's the only modern example of any law surviving strict scrutiny. Okay, you with me so far? Stop me if you don't get this.
Okay, so on when the Japanese were sent to the camps, would that be narrow or broad?
Well, if you ask the majority of the court, they said that was narrowly tailored, that they couldn't act any more narrowly. We know today that that's not correct.
Right.
They could have done a million other things. But in theory, at least, the idea was they acted as narrowly as they could. That the only way to root out this threat from the Japanese was to put them in concentration camps. I would ask you to think, when you do strict scrutiny, try not to put too much effort into Korematsu because it was a really bad case. Think of the Michigan affirmative action case, because at least they attempted to square it with doctrine, right? That they use race in a very limited context with this, holistic, one of many factors. And they said that the benefits from diversity are so compelling that they justify the use of race in this limited fashion. Everyone, questions? You should be able to recite the sentence in memory. You need to recite this entire everything from memory, okay? And explain to me why it applies. Same way I just walked Connie through the affirmative action case, right? Diversity benefits are so important. You use race in a limited context. Like that's an answer you write in your exam, very precisely. I want you to see if you actually understand how to apply this test. Don't just recite the test for me. That won't get you anything because you can copy it from your notes. Okay? We move on to intermediate scrutiny. Okay? These apply to things like gender and legitimacy. Although we don't have any legitimacy cases anymore, we do have gender cases. And these are called quasi-suspect classes. It's not quite suspect, not non-suspect. It's somewhere in the middle. We don't exactly know where, but it's somewhere in the middle. And the test we use here is the classification substantially related to an important governmental interest. Is the classification substantially related to an important governmental interest? You notice that this is less strict than strict scrutiny. Compelling drops down to important, right? Maybe national security is compelling, but having integrated military academies is important. We have this other test, substantially related versus narrowly tailored. With race, you have to act very narrowly, right? Using race as one of many factors. With gender, you maybe have some more latitude. An example I use here is one that comes up very often, having segregated sex bathrooms, right? Is it constitutional for a city or a public university to have bathrooms that are segregated by sex? Is it important governmental interest to protect privacy of people who might not feel comfortable? Probably. Is having segregated bathrooms, related to that goal? Yeah. Okay, so maybe the segregated bathrooms survive. What about segregated military academies, a VMI case? Well, is having, creating strong citizen soldiers an important goal? Yeah. But is it necessary to have segregated schools to do that? No. The court said you can have the same program for people of both genders. So at each test, right, the burden changes. With strict scrutiny, the government has an absolute burden. With intermediate, the government has a high burden. What do I mean by that? The government really needs to show evidence for strict scrutiny that they can justify it. Here, They need some evidence, but they don't need quite as much. It's more permissive, if you will. Everyone else with me? Yes, ma'am.
Is there a big difference between compelling and important?
Semantically, yes, but the short answer is yes. Compelling is a lot bigger than important, right? Basically, we have in our case law what's compelling: national security and the benefits flowing from diversity. And I don't mean to say that glibly, but the courts basically identified two things that are compelling: national security and the benefits from diversity. And if you believe Justice Thomas's dissent, the latter is not nearly as important as the former. But we have that in our case law. That make sense? Okay, other questions on quasi-intermediate scrutiny? Okay, move on to rational basis. Okay, this is a classification based on basically everything else. For example, age. We call these non-suspect classes, as if you need another word to learn, right? You have suspect classes, you have quasi-suspect classes, you have non-suspect classes. Drives you nuts, right? This is basically everything else that is not race, religion, nationality, gender, whatever. Age, okay? When the government's making a classification based on some other basis, we apply the least amount of attention to it. Courts are generally going to defer. And the test, which I think someone asked about Lochner a minute ago, right? I'll get to Lochner in a bit. But the test then was, is a classification rationally related to a legitimate governmental interest? Is a classification rationally related to a legitimate governmental interest? So we drop even more. Okay? Instead of it having to be compelling or even important, it's legitimate. What does legitimate mean? Basically, anything the government wants to do that's not stupid is okay, right? As long as the act itself is not like some sort of horrible deprivation of rights, it's legitimate. What does rational related mean? If in someone's mind, can they connect points A and point B, right? If in someone's mind, can they connect two different elements? So the easiest example I gave is driver's license. If I'm 17, I can get a driver's license. If I'm 16, I can't. Is there a rational reason why we're discriminating on the basis of age? Sure, maybe the legislature thinks that 17-year-olds are more responsible and they can drive better. Do they need like studies and statistics to prove that? No, they don't. So in this case, basically, the government has no burden, and the plaintiff has an impossible burden. Because basically, the plaintiff needs to show that no rational mind, no human being could ever come to the conclusion that 16-year-olds and 17-year-olds maybe have different maturity levels that can drive differently. Okay? But let me throw this one up a bit, right? Let's say a state passes a law that says girls can drive at 16 and boys can drive at 17, right? Women can drive at 16, men can drive at 17. Although that's a classification basis of age, gender is inserted. And because gender is inserted, it becomes something that, and then you'd have to, like, a substantial relationship, not just some sort of a rational, but actually some sort of significant reason why men can drive later than women. That was the Craig v. Boren case. Okay? These three, you need to have cold. I'm not going to keep going over this again, but you need to have this solid. Comprende? All right, any questions about these three before I move on? Yes, ma'am.
Where is the rational basis test outside of classification? Is that the same?
You're like 30 seconds away. That's my next thing, I promise. Yes?
Do disabilities fall under the everything else?
Disabilities is everything else. Okay? There was a note in the book which I didn't spend much time on, but there are a couple cases that suggest when there's a discrimination on the basis of disability, it's something called like rational basis plus or rational basis heightened. The court, again, which drives me nuts and will drive you nuts, is that there's not just one type of rational basis test. At various points, the courts have applied the rational basis test with more oomph, shall we say, with more vigor. But they still call it rational basis. It's somewhat maddening. For your purposes, this is good enough. But disability would be rational basis, strictly speaking. Bad choice of words. Other questions on these three? Yes?
So how do age discrimination laws actually get passed if they're under this rational basis scrutiny? Like you mentioned that with the 7-year-old cutoff for judges and on the bench.
Those will mostly survive. Most mandatory age requirement laws, not all, but a lot of them do survive. Because legitimately, a government, we don't think they're sitting the bench because they're not as sane. So those laws, I'm not gonna say always, but generally do survive.
It's funny that that's upheld by the Supreme Court and they're all
Yeah, right. Yeah, Hector.
What are some examples of illegitimate government interest?
Trying to hurt people, trying to take away property, like doing something that's legitimately evil. But again, the number of cases where a rational basis classification is actually invalidated are very little. So I mean, I'll give you an example, right? I gave this example before. So a state passes a law that says only ophthalmologists can fit lenses, right? Opticians cannot. Okay. What's the state interest there, or governmental interest there? Protecting the eye doctors. Hector, is that a legitimate state interest? Oh, you're generous. You think protecting doctors at the cost of other people in the business is a legitimate state interest?
Protecting doctors at the cost of...
Yeah, by blocking other people from entering the market. Is that legitimate? The answer is yes. Right, so the answer is yes. Your first answer was correct. The courts have held that the state... The court has held that the state can decide that they want to create a barrier to entry. That the state can limit a certain profession and block people who can participate in that market, and that's legitimate. Protectionism is a legitimate interest. So if that's legitimate, just about anything is. Yes, sir. What do you mean intelligence? Mentally handicapped?
Yeah.
That's kind of like a disability, no?
Okay, so that was wrong.
Right. I think meant really smart people, but I guess is going the other direction. Other questions on this?
You know that Kilo case where they took that lady's property?
Yes, I know it well.
So that rational basis scrutiny, that's what they do that? Is that how they...
So I don't do takings in this class, but you'll study this in property. The test that Justice Stevens applied, the majority opinion Kilo, was rational basis by another name. It wasn't called that, but if you want to compare it, that's basically what it is. But it's not exactly rational basis, but it's of the same, it's of the same flavor. Other questions on this? Okay. So again, these are your 3 tiers for equal protection scrutiny. But now we move on to substantive due process. And this is going to be a little bit easier for you. Rather than carving up classifications into 3 categories, the Supreme Court has divided rights or liberty interests into 2 categories. It's a little bit easier. Fundamental rights and non-fundamental rights. Okay? The fundamental rights and non-fundamental rights. The word fundamental is a word you probably heard 1,000 times before, but never actually bothered looking up, right? What does fundamental mean? Well, it doesn't really have any meaning, but courts understand it to mean a really important right. So fundamental rights are, I'll put in parentheses, important rights, and non-fundamental rights are unimportant rights. Now you're saying, wait a minute, Josh, who gets to decide which rights are important and which rights are not as important? I'm sure if I took a poll in this room, there's 70 of you, I would get 7 different answers about what rights you think are important, which rights you think are not important, right? This is the issue teed up in Griswold v. Connecticut, which we'll study later in this class. But the Supreme Court has, whether it wants to admit it or not, taken upon itself to divvy up, to divide up the rights we have. Okay? And this was largely done, of all places, in a footnote. Yes, my friends, a footnote. Footnote 4 of a case called United States versus Carolene Products is the most important footnote in Supreme Court history. Okay? It was in your readings for the last class, and I assigned it, but I deliberately didn't get to it because I wanted to save it for here. So let's talk about the case of United States versus Carolene Products. Anyone know what this is? Filled milk? Anyone ever use it? It's basically condensed milk. So imagine in an age before refrigeration, right? Milk was very, very expensive because you had to always keep it refrigerated. Refrigerators were expensive. Filled milk does not need to be refrigerated. It can be canned. So very simply speaking, what you do is you take the milk, you basically extract all the dairy from it, and you insert vegetable oil, some sort of a coconut oil. And whenever you use this, like to make like dulce de leche, it's good stuff. Yeah, it's real yummy. I have an entire case in my office. Okay. Oh, wait. So in the 1930s, there was a guy named Charles Hauser. Okay. He was an industrialist who decided that he wanted to market this form of filled milk. Okay, let's start going around the room. Oh, where did I finish up last time? Thank you. Okay, all right, Megan. So, Megan, think this through, right? So he's basically making a product that's effectively milk, but can be canned, and you don't need refrigerators, right? Who do you think is going to oppose his business? Yes, the dairy farmers, right? This is a Baptist and bootlegger scenario. The dairy farmers were very influential, and they opposed everything. So, by the way, everyone know what margarine is? It's like a butter substitute. They was actually lobbied to pass laws that said margarine has to be pink. They had to dye margarine pink so it looks so funny. So no one confuses it with butter, right? You have to make it look like this ugly product. States actually ban margarine because basically you don't need as much dairy. It's a chemical product with a vegetable oil and stuff, right? They were livid about this product. They said, oh, no, we can't have this filled milk. It's so unhealthy, right? So they said to the state legislatures and federal government, you need to ban filled milk. You need to ban this product. Why? Unhealthy. They said it's bad for you. And by the way, it's healthier than real milk because it doesn't have the same cholesterol. It's actually healthier for you than real milk. Well, let's put aside science for a minute, right? So they basically lobbied in a number of states to criminalize the shipment in interstate commerce of filled milk. And we did the Commerce Clause a while ago. But this case was decided in the 1940s, and by that point, the court already held that commerce means whatever you want, right? And shipping anything across the state line, doesn't really matter what it is, it's interstate commerce. So Charles Hauser built a factory in a genius way, and I spoke with his grandchildren about this. I interviewed them, right? He built a factory on the state line in Missouri and Oklahoma. You can see this little dotted line right there. He built a factory on the brass rail going down the middle of the factory. This guy's a genius, right? And at no point were any products allowed to cross that brass rail. He had cargo doors on both sides, so he could ship to 2 states from 1 factory. This guy was a genius, right? He basically spent his entire life trying to evade the Commerce Clause. He's a man after my own heart, right? Yet, he was so livid that when this law was passed, and this is the family story. I'm pretty sure it's not true, but this is what his granddaughter told me, that at one point, he said, I want to break this law to challenge it in court, okay? So he got into a milk truck, loaded up, and drove across the border for the explicit purpose of getting arrested. I'm pretty sure that story is not true, because I looked into it. It doesn't make sense, but that's what his granddaughter told me, so I'll tell you the story, okay? So there were not 1, but 2 Supreme Court cases, right? The first one, which we'll discuss in a minute, is this case, United States versus Carolene Products, where the court upheld the constitutionality of this Filled Milk Act. The second one actually involved him driving, or someone in his company driving across the border and getting arrested for this product. So eventually the Supreme Court upheld his conviction, but I actually discovered this was very cool. After he spent years fighting the Roosevelt administration, FDR gave him a pardon. And this I discovered, I couldn't even believe this was true. And there's actually a copy of Roosevelt's pardon to Charles Hauser, okay? And there's a copy of his a letter, which basically means he gets out of jail free. The craziest part of this, though, is that Roosevelt issued this about a month before he died. So this is probably one of his last official acts of government as President of the United States, by freeing this guy. Crazy story. And this was actually hanging on the wall in his lodge back in Missouri for like 40 years because he was really proud of it. Anyway, but why am I telling you this story? In the process of deciding this case about Milnot, this is the name of the product from United States versus Carolene Products, the court put this footnote into their opinion. Okay? It's a long footnote. And if you go to the end of your notes from last class, you'll see them. It's in the book, but I have it in the board as well. Okay? Actually, so actually it's on page, I'll give you the page number. It's on page, should be around 476 or so. Is that right? I don't have the book in front of me. 475, 476, footnote 4. Oh, it's up here. Give me stop. Okay. The purpose, it's on there? Okay, I thought it was. The purpose of footnote 4. All right. The purpose of footnote 4 was to answer the exact question, which I think Connie asked me a couple of minutes ago, right? How do we know what kind of scrutiny do we apply to different rights? Okay, it's on there, just up here. Yeah. Here. How do we know what kind of scrutiny do we apply to different rights? Okay. We know, and I told you this before, that we have these things called fundamental rights, and we have these things called non-fundamental rights. That some rights are very important, and some rights are not important. How are courts to know which rights, which liberty interests fit into which category? So we get footnote 4, which I am not oversaying this, is the most important footnote in constitutional history. In a footnote of all places, they basically decide how rights are defined. So we begin. It says, there may be a narrower scope for operation of the presumption of constitutionality. Mary, what does that mean? I discussed this in maybe the first or second class. I know I'd get back to it eventually. What does this mean, a narrow scope for the presumption of constitutionality? What's a presumption of constitutionality? Give me more. To a judge, what is a presumption of constitutionality?
That it's constitutional unless
So if I'm a judge, right? You have like Lady Justice balancing the scales, right? I put my thumb down on one side. Where am I putting my thumb? On yes. Okay. Joe, you want to add something?
No.
Okay. So I'll come back to you. Don't worry. So the presumption of constitutionality is exactly like Mary said. Imagine Lady Justice holding the scales of justice, and you imagine her having a blindfold. But that's something of a fiction, because under a presumption of constitutionality, you're putting your thumb down on the side of the government. You're putting your thumb on the scale of the law being valid. You're pushing it down, right? And the side of the individual rights, that starts weighing a little bit less. So what Stone says is generally we have this presumption of constitutionality, where generally we presume that laws are valid. But this presumption is not always going to apply. Where is this presumption not going to apply? Or where will this presumption have a narrow scope? Right? Narrow scope means we're not applying the presumption of constitutionality. Well, we begin. If there is a specific prohibition in the first 10 amendments, right? If there's some sort of specific prohibition in the first 10 amendments of the Constitution, if there's a law limiting free speech, or free religion, or freedom of the press, right? Don't ask for the Second Amendment. We won't get there yet. If you notice, the Second Amendment's not mentioned anywhere in today's readings. But in theory, it's in the first 10 amendments. If there's a law that touches on something in the first 10 amendments, the presumption of constitutionality is limited. In other words, We don't put the thumb down on the scale of Lady Justice for the government. We don't do that. Okay? So, Joe, what do you think about that? If we're deciding what rights are fundamental, do you think it's fair for judges to say if a right's in the first 10 amendments to the Constitution, then that's a fundamental right? Does that seem reasonable to you?
Yes,
Why does that seem reasonable to you?
because those are the specific rights that the founder says.
Yeah.
There's no chance you can mess with these.
Yeah, yeah. I mean, these are not. This one's not controversial, right? It's in the Constitution. It was ratified by the framers. There's no doubt here, right? But now we move on to things which are not clearly in the First Amendment, and we've discussed this before. The 14th Amendment protects life, liberty, or property, right? What is the meaning of this word liberty? What are these liberty interests protected? It's here that we can't do like what Job said, just look at history. We have this phrase which means something, okay? So the second part of this footnote says, legislation that restricts the political process. They include things like restrictions on the right to vote, restrictions on sharing information, restrictions on interfering with political organizations, prohibiting peaceful assembly. Crystal, let me ask you this question, right? What is this political process they're talking about, right? What about these restraints on the right to vote? Why might those be important rights that the Constitution, that the courts protect? Oh, no, don't talk about privacy yet. That's later. Look at these things. Right to vote, restraints of information, political process, right? Why might it be important for the courts to treat these sorts of rights at a higher level than others? Give me more. Well, that's actually the opposite of what they're saying, if I agree with you. Let me ask you this question, Crystal. How are people expected to change their government? By what means? And don't say the courts. The political process. Generally speaking, right, the political process is used to change government. You vote, you assemble, you organize, you share information, right? Crystal, what happens when those rights are infringed? Yes. Yes, exactly right. When those sorts of political process rights are violated, the people can't change their government. We did this case with, remember the grandfather clause case where if you were black, you couldn't register to vote by this day, and they had all these other requirements. And they said, listen, we're not going to be able to change our government, right? We will never be able to change this law because we ourselves can't vote for our own members of the state representatives. So the argument goes like this. When you have some sort of political process, something that affects how people vote, how they share information, it might require more exacting judicial scrutiny, right? Instead of putting your thumb down on the side of constitutionality, you put your thumb on the other scale, on the side of what we call liberty, right? So instead of having a presumption of constitutionality, you apply what may be called a presumption of liberty, right? You presume that the individual should be free and that this law is bad. Yes. I'm sorry? Narrow scope of what? Well, okay, so let me use the word you said, right? Use this word narrow scope. A narrow scope of what? Here, it's a narrow scope of the presumption of constitutionality, right? Ditto with political process. You are going to apply the presumption of constitutionality less. It's more narrow. You're going to focus more on presumption of liberty. Everyone get these two concepts, right? You have a presumption of constitutionality, and you have a presumption of liberty. These are different thumbs you can put on the different scales. When there's a right in the first 10 amendments, or a right that affects the political process, you take the thumb off the constitutional scale and you put a little bit more on the liberty scale. You kind of rejigger the calculus because you suspect that this is a law that's probably trying to do something that should not be done. When there's a fundamental right at play, you reduce this presumption of constitutionality and you increase this presumption of liberty. They're two sides of the scale. When you lift one up, the other one goes down. The other one weighs more. Sarah, does that make sense? That makes sense to everyone? Make sure you get this concept because it's not the most intuitive. But if you think of the scale and the different, the weights that are going up and down, I think it makes a little bit more sense. Okay. Okay. So which are our rights which he deems fundamental? Well, if it's the first 10 amendments to the Constitution, if it's something involving political process, okay. Also, if it's directed at religious, national, or racial minorities. By the way, bonus question, Hector, right? Where have we seen these three groupings, religious, national? Where have we seen those groupings before?
Equal protection.
What kind?
14th Amendment.
Which tier of scrutiny?
Oh, scrutiny.
Exactly. You wonder where that came from? This is basically defining which classifications. If you notice, they pivoted from rights, like voting, to classifications. I'm telling you, this footnote does a lot of heavy lifting. So, right? So paragraph number 1, right? The first 10 amendments to the Constitution. Paragraph number 2, different forms of liberty interests. Okay? Paragraph number 3. This is how we have different kinds of classifications for purposes of equal protection. All right, it's doing a lot of work in very few words. You guys complain about a 500, 1,000 word limit for your exam. This is like a 700 word footnote that describes constitutional law. So don't complain about your word limit. Okay. So we have, if you have some sort of classification that's directed at religious or racial or national minority, right? That is something that gets heightened scrutiny. You have this strict scrutiny or presumption of constitutionality. Okay? But then we get this, right? And this is the part that students have the most difficulty with, so I'll spend a minute on it. Where there's some sort of prejudice against a discrete and insular minority. Connie, what do these words mean, discrete and insular?
Insular, I'm not sure what that means.
What does discrete mean?
Discrete means
Hey, anybody know
not public
what
or
do you put in a thermos to keep it warm? What do you call that? Or what do you put in your house to keep the heat out? Insulation. Insular. What do you think insular means? What do you think, Vicky?
I can think of it to enclose or
How would people be insulated?
um
And don't tell me a sweater. Thank you, Jimmy Carter.
I keep thinking like a camp or something.
Politically, Aleda, how could a person be insular or discrete?
I would think not running a lot of things.
Okay. Michelle, politically, how could someone be insular? Think of the political process, right? How could someone be insular?
I guess by
Or not being able to? Okay? Here's the key. Footnote 4 doesn't just restrict it to religious or national minorities. It's trying to think more big. If a person, specifically a minority, and this doesn't mean racial minority, and people always say, oh, minority, that means like, racial. No, that's not what it means. He just said nationality. He already did that, right? This is something different. These are people who lack access to the political channels. They are insulated. They are separated from the political process itself. This is something known as political process theory. It's a very popular school of constitutional thought. That the reason why we have these judicial review is to ensure that people can access the political process. The thinking is, as long as people can vote and access the political process, they can change government for better or worse. And if they can't do that, then we break down the political process. Courts need to step in and make sure that these discrete and minorities are getting their proper representation. In other words, we don't assume that they are being represented properly. The court, the representation, right? Give them an extra oomph to make sure that they have a say or a voice in the popular arena. Hector? Political process theory or representation reinforcement. You can call it either one. But the idea is for certain minorities are discrete and insular, right? And this doesn't mean based on a person's skin color or nationality. Again, that was already covered up here. This is, you know, poor people maybe, right? Or law that targets people who are uneducated, right? I say, wait a minute, Josh, didn't you just say, you know, equal protection, if it's not race, whatever, it's rational basis and the government wins? Yes. This theory lurks in the background, right? And I'll mention this a couple points today. But very often, when some sort of law affects people who are discrete and insular, the court gives a little more oomph. They give a little bit more thumb on the scale of liberty. It's not any doctrinal change. Like, there are no different tests. Everything's called the same. But if you look at how rational basis is applied, in some cases, they'll actually bring up footnote 4 and say, wait a minute, we got some insular minorities, people who can't, you know, they're uneducated. They don't know how to vote. No, there are laws infringing the right to vote. We have to give them some more process. Yes?
How does, like, the fact that, like, felons can't vote fit into this, or does it?
You know, it's a really interesting question. So her question was, how is it that felons can't vote? So in some states, the government can restore voting rights, but it's not a written obligation. The Supreme Court has upheld within the last 20 years in a dicta that that a felon basically surrenders certain civil rights afterwards. I think those are on really dubious footing constitutionally, but the courts have held that. There's not really good analysis there either. In a case, we'll actually study a case next week called Romer versus Evans, and it's actually mentioned in like 2 sentences in that case.
So they didn't analyze that problem, like, under any of this?
Not really. You'll see it when you read Romer next week. I won't spoil the surprise, but there's like 2 sentences on there, 3 sentences. There's not a lot. But your instincts are correct. I think there are definitely questions about how a person who served his time can continue being deprived of civil rights. And I would include this great article called "Why Can't Martha Stewart Own a Gun?" Which discusses why white-collar felon like Martha Stewart is permanently deprived of her Second Amendment rights. I think there's actually a legitimate question there. But anyway, the court is so held. Okay. Other questions on footnote 4? All right. So we see here 2 things. Okay. This provision of footnote 4 identifies all the rights that are fundamental. So I think I told you I left this blank, right? How do we know if a right's fundamental? Well, we apply more or less the framework of footnote 4. Okay? It's not precise. The list here is not complete. Make that very clear. That is not a complete list of the fundamental rights. We will be adding to that list throughout the course next week or so. But you basically apply the footnote, about the footnote 4 framework, right? Flip side to that. Okay, Maria, what happens if a right does not fit into the footnote 4 framework? What kind of right is it? Exactly. This is the okay. Footnote 4 provide all these frameworks deciding which rights are fundamental. Okay? But by doing so, it split rights in half. It bifurcated rights. So remember the expression in contracts, expressio unius? If you include these, you mean you exclude others. Ever remember this from contracts? Same thing applies here. When the court says all of these rights that fit into this framework are fundamental, everything else is not fundamental. And oh, by the way, much like above, fundamental rights get something approaching strict scrutiny. And non-fundamental rights get protected rational basis. So with this simple footnote, the Supreme Court chopped in half like a guillotine our entire corpus of rights. The entire corpus of rights were dissected and chopped in half. Any rights which were deemed fundamental, and this list will keep growing, are given what's called strict scrutiny or something close to it. If a right is not in that bucket, it's not fundamental, you give it rational basis, and that means the government wins. Okay? Everyone get that much so far? Why was it so important, Adela? Why was it so important for the court, and this is the New Deal court in the 1930s and 40s, to separate rights? What do you think was on their mind? And think about our last class. Why was it so important to protect some rights but not others? What were they trying to exclude from this framework? What was this controversial case we did last week? Lochner. What did Lochner hold? Now, what was the holding of Lochner?
They held that in order to protect liberty, acres were not limited to
Good.
60 ordinances.
Good. All right, Whitney. What was the liberty interest asserted in Lochner? What was the right that Joseph Lochner asserted? What do we call that? Yes, the liberty of contract. I remember this from last week. I know it was a long time ago. But you need to remember this stuff, right? The liberty interest asserted in Lochner was called liberty of contract, or economic liberty, if you will. The greatest existential threat to Franklin Roosevelt and the New Deal was the Supreme Court and liberty of contract. The idea that the Supreme Court could strike down progressive legislation that violated this liberty of contract posed an existential threat to FDR. And the justices he appointed recognized that very well. So one of the core aspects of this bifurcation of rights with footnote 4 was to jettison, was to discard economic liberty to the ash heap of constitutional history. Economic rights were deemed non-fundamental. Right here. Economic liberty. This was deemed the most unimportant right that we have. That the right of the state to infringe on your contract rights, whatever. Progressive legislation trumps. This was critical to allowing progressive legislation in the New Deal to prevail, right? This meant, although this wasn't directly overturning Lochner, this basically said the entire framework on which Lochner was based was wrong. That courts will not sit and second guess the judgment of the elected branches. That the elected branches want to limit hours to 60 hours a week, they can do that. If the elected branches want a minimum wage, they can do that. If the elected branches want to set working conditions, they can do that. Judges will not sit in judgment of those opinions.
Can you tell us again when that case was done and who wrote that opinion?
It was United States versus Carolene Products. It was Chief Justice Stone, 1942. I don't have the year in front of me. You can Google that. I think it's like 1942 or so. Oh, okay. 1938. Thank you. Off by a couple years. 1938. Okay. So in other words, the only time under footnote 4 where the courts will intervene is when there's some sort of right in the Bill of Rights. Here, I'll write this, make it clear. Bill of Rights is BOR, the Bill of Rights, or political process. The only time the judges will get involved in second guessing the wisdom of legislation is if there's some sort of prohibition in the Bill of Rights, or this gets in the way of political process. right to vote and other things like that. Otherwise, everything else, courts will not second guess the elected branches. Courts will not second guess the elected branches. And laws will be upheld. So far, everyone get this? Any questions? Stop me if you don't, because this is basically like the summary of this entire topic. Hector?
The footnote says it is unnecessary to consider about the political process.
It does say that, doesn't it? But by saying that, they're considering it. Right. So when courts say it's unnecessary for us to talk about it, let's do it anyway, that's saying we're talking about it. In fact, oh, and Hector, I'm glad you raised that. Just last year, an opinion, Justice Scalia called footnote 4 a dicta. Oh, what do you call it? A dictamizer? Oh, I forgot the phrase. He had this great turn of phrase. I think he called it a dictamizer, something awesome. Oh, God, what was it? I might have to Google this. Scalia, footnote 4. I Googled too. It's called like a dictamizer, a dicta something or other. But yeah, Hector, you're exactly right. Let me read this. Let me read this to you because it's actually pretty good. I remember I blogged about this last year. So Hector, effectively footnote 4 is a dicta by itself, but it's become the most important footnote in Supreme Court history. Okay, so he says, the dissent trots out the old saw, derived from dictum in a footnote. From that dictum, because the dictum itself merely said, nor need we inquire. Okay? It says, that alone demonstrates the prudence of Carolene products dictamizers. By the way, Scalia, his words are beautiful. By calling it dictamizer, he's making a portmanteau of victimizer and dictum. It's a beautiful turn of phrase. But yes, Hector, you're right. We should not design our jurisprudence to conform to a dictum in a footnote in a 4-justice opinion. So it doesn't even have 5 justices to it either. But yet, this is the defining characteristic of our Supreme Court case law. Okay? Any other question, footnote 4? Okay. So what's going to drive you nuts now that you got that, right? Is that the category of fundamental rights was not limited to what was in footnote 4. The next week, next class in Roe v. Wade, the court would expand the scope of political process. I'm sorry. The court would expand the scope of fundamental rights without any reference to political process. We'll do this later today, but ask yourself, how is acquiring birth control in any way related to the political process? It's not. Shouldn't a right to birth control be everything else? Yes. But the court basically breaks down this framework. But it still exists. So what they said was, well, you know what? Birth control, fundamental right. Abortion, fundamental right. Sodomy, kind of fundamental right. And they keep adding to this list. All right? Everyone with me so far?
So they're kind of doing to this what they did to the Commerce Clause. It's like,
Yeah, they're good at that. They're good at whatever that is, but they're good at that. All right, everyone with me so far? Make sure you understand this. These two tiers for the substantive rights and these 3 categories for protection, you should be able to recite it from memory and understand how to apply it. I'm not going to do this again, so make sure you get it. If you want, you can watch a video. It's online, but make sure you get this, okay? Good. All right. So let's move on to today's class. And we actually already did a lot of it, but there are 3 cases I want to discuss today which describe various aspects of liberty interest protected by the court. 2 of these cases were decided before footnote 4, and one of them was decided after footnote 4. Okay? The first 2 cases were decided during what could be dubbed the so-called Lochner era, which is a phrase I don't very much like. But it was a time period where the court said that there's a liberty interest in the 14th Amendment, and courts can invalidate laws that violate that liberty interest. Okay? The first case, Pierce v. Society of Sisters, actually has a preview case. which was mentioned briefly in your book, but I'll discuss. It was called Meyer v. Nebraska. Meyer v. Nebraska in 1923. What was Meyer v. Nebraska? The state of Nebraska banned teaching of any foreign language in schools. All right, Tiffany. If the year is 1923, why do you think Nebraska would ban the teaching of any foreign languages in school?
Enough immigrants.
Good. What language do you think they were trying to ban particularly? 1923. What was going on in the world at that time? German. You may not know this, but there was a serious... Oh, wow, I said that. Anyway, German, yes. You may not know this, but there was a serious anti-German backlash during World War I in the 1918, 1920, right?
They're just mad because I'm German.
Oh, you're German? Okay. That was my next line, yes. During World War I, there was a serious anti-German backlash in the United States. They called sauerkraut freedom cabbage. They actually, I have a dachshund, they would kill dachshunds because they were German dogs. Break the wieners in half. Yeah, it was very sad, right? So this was a law. This was a law that was based on very strong nationalism, right? They were just trying to say, we don't want any immigrants. I'm sorry, Tiffany. They don't want any people teaching. That's never happened before. They don't want any people teaching German in high schools or any kind of schools, right? So this went to Supreme Court. And what did the Supreme Court hold? That this law is unconstitutional. Okay? So one point to stress, this was not a First Amendment decision, right? This wasn't a law saying that you're discriminating on the basis of free speech, right? You're telling people you can't engage in speech. I think this is a good free speech case. You can't engage in a foreign language. You can speak whatever language you want. So number one, it was not a free speech decision. All right. Number two, it was not an equal protection decision. It was not an equal protection decision. Okay. Cindy, in 1924, what was the standard, right, for equal protection law? What was the defining case in 1924? Equal protection. Oh, come on. What was the major case involving equal protection that survived for almost 50 years? Before the school case. School is Brown. What came before Brown? Oh, come on. Jason? What was the defining equal protection case before 1924? You need to know time periods, people. This is on your exam. Right? What was the case? Someone said it. Plessy. Yes, Plessy, right? The train case, right? In 1924, the Supreme Court's case law said, yeah, you can discriminate on the basis of race as long as it was equal. Sure, you can ban teaching of languages or whatever. That's no problem. Okay? So it was not a First Amendment speech case. It was not an equal protection case, right? So what are we left with, Alejandro? What other basis could this law violate? Not equal protection, not free speech. What other basis could this law violate? What do you think? We only have a couple clauses.
The only other thing I can think of is due process.
Yes! And what aspect of due process?
Government interfering
With
liberty.
liberty, yes! This is what became known as substantive due process, that there was a liberty component to due process clause. And by banning the teaching of foreign languages, the state was infringing on liberty interests. Right? This infringes on the liberty interest. Teaching a foreign language in a school, raising your children how you want to speak a different language. This was viewed not as equal protection violation, but as a liberty interest. And the state, with its progressive laws, could not interfere with that liberty interest. Everyone see that? How far the New Deal court wanted to distance themselves from this? This was Lochnerism. The court was second-guessing the wisdom of the legislature to interfere with the private affairs of people. If people wanted to learn and speak German, that was their business. Damn it, right? They can do whatever they want. So that law is unconstitutional. Our favorite, Justice Holmes, right, we'll get to later, said, I am not prepared to say this is unreasonable, right? If the state wants to decide that only English can be spoken at schools, that's a job of the state to decide. Okay? But the majority said this is bad. That was 1923. We fast forward to 1925 with the case of Pierce v. Society of Sisters, which is the case I signed. Sean, what were the facts of Pierce v. Society of Sisters?
Basically, the state of Oregon
Yep, Oregon, yeah.
stepped in and said that all the children there had to go to public schools. And so,
Okay, so let's stop you there. Why do you think the state banned, or why do you think the state required that everyone must go to a public school?
why do I think?
Yeah.
Thanks for indoctrination. But
Close. Sean, let me ask you this follow-up question. The 1920s, right? What do you think the only private schools were in most states?
religion,
What kind of religious schools?
those were Catholic.
Catholic. Okay. Sorry, are you Catholic? I yelled at her for German. I yelled at you Catholic. Whoa, I'm winning today, right? Catholic schools, okay? So again, there was a serious anti-Catholic sentiment in the United States. Very strong. Look at what happened with President Kennedy. People thought he was like a Manchurian candidate for the Pope. I mean, this went on for very long. I'm serious. There was a serious anti-Catholic backlash. We don't have that today, thankfully, but this was a prominent part. This was a movement, I am not joking, which was sponsored by the KKK to get people out of Catholic schools. This was meant to shut down Catholic schools. Because if you say, oh, only private schools are allowed, right? Only private schools are allowed, that basically renders every Catholic school illegal. And as well, a military academy such as this one, which was, I guess, on the fringes. Okay? So again, this case was not a First Amendment religion case. This case was not a First Amendment religion case. This case was not an equal protection case on the basis of religion. Okay? So again, Neffy, it wasn't a First Amendment religion case. It was an equal protection case. What is the basis on which this case was decided?
Fundamental rights.
Under which provision of the Constitution?
It's the freedom of.
You said fundamental rights. Where do we get fundamental rights from? Which provision of the Constitution? No. What was the list we just did when I asked you to memorize?
Scrutiny, which is.
No. Caleb?
You talking about the Bill of Rights? It's not the Bill of Rights?
No, it's not the. Where do we get fundamental rights from? Which provision of the Constitution are we talking about today?
You're talking about due process?
Due process and substantive due process. You need to know this. If I am talking about liberty interest, you need to look to the Bill of Rights. You do not look to the Bill of Rights. Throw me off scale. You do not look to the Bill of Rights. You look to the 14th Amendment's due process clause. This is substantive due process. Okay?
If it's a federal statute, do you never to the Fifth Amendment?
In theory, yes. Yes. We'll get to that later, but the short answer is yes. Okay? So what do we have here? Caleb, what is the liberty interest at play here in Pierce v. Society of Sisters?
Whether or not parents can choose where to have their kids educated?
Yes. Yes. This is a liberty interest for parents. And that parents can choose where to educate their children. Okay? And that the state cannot arbitrarily interfere with this right. The state didn't just regulate schools, right? They didn't just say, oh, schools have to have these kinds of curriculums and these kinds of standards, right? They said, we are banning these schools, period. No ifs, ands, or buts about it. This was considered an unreasonable restraint on the liberty interest of parents to raise their children. Also, Sean's right. There was some sort of indoctrination there because you're forcing the people to accept instruction from the state. It was like Common Core back in the 1920s, right? It was a total form of control. Again, this is Lochnerism, no matter how much people want to deny it. The state passed progressive laws saying we want to promote education in public schools. The Supreme Court said, no, we don't agree with your judgment because parents have the right to decide where to send their children. This is a liberty of contract issue. Parents can choose where to sign their kids up for school.
Why would somebody want to deny it?
Deny what?
What would you mean by that? I don't get it. Maybe I misunderstood. When you said this is Lochner, somebody would deny it.
Because the entire premise of the New Deal is that we can't be Lochner. We cannot have economic liberty. So you'll see later when we do the Griswold, the birth control case, they cite Myers and they cite Pierce, but they do not cite Lochner. And Justice Black's dissent makes clear, let's not kid ourselves here. We are doing Lochnerism. So the long and short of it is, the entire essence of the 1940s to 1960s was finding a way to protect judge-created rights without recognizing Lochnerism, right? Finding a way to protect judge-created rights, for example, abortion or whatever else, without providing for economic liberty. That's it. That was the enterprise of the New Deal and Warren courts.
We said it almost.
The purpose of all the cases from the 40s to the 60s was finding a way to protect various judge-created rights without recognizing Lochner. It's insincere at best and disingenuous in reality. Okay? So you have these two cases. One saying, you know, the state can't ban the teaching of German or any foreign languages. And you have another saying states can't ban private schools. Both interfere with liberty of the individual. By the way, I want to just stop and pause for a second. Jocelyn, who is the plaintiff? Who is the plaintiff in Pierce v. Society of Sisters? Who is challenging the law? The Society of Sisters. Is this an individual? What is the Society of Sisters? A corporation. Are you trying to tell me that corporations have constitutional rights? Yeah, kind of, right? Thank you. That was actually a perfect answer. Kinda. So contrary to whatever you might hear in the media, for at least, what's case 90 years old? At least 90-year-old case, right? Courts have held that corporations can exercise various rights. But even more so, Jocelyn, I'll ask you a follow-up. Whose right are we talking about here? What is the right at issue? What's the liberty interest? The right of parents. So effectively, a corporation is asserting a right on behalf of parents who go to the school, right? A parent pays money to the school to send their kid there, right? The corporation is asserting a right on behalf of one of its constituents. Imagine that. Now, people come together and they join a school, that their rights can be protected by the corporate veil. Imagine that. Also, the court says that corporations have business and property rights. Because think about it. Once you shut down these schools, once you ban private schools, these schools shut down. They're out of business. Done. They have no money. They have no students. They have no money. So the court recognizes not only that the corporation can assert rights on behalf of its members, but also the school has a property interest by itself to protect against arbitrary interference with its property rights. So there's a right to the parents and also the property rights of the corporation itself. Okay, everyone with me so far?
Can I ask one more question? If you were gonna, would you analyze that? Would it be helpful to analyze it by doing the means and the ends and saying this is what they wanted, this is how they're gonna do it, it's too much because is that what the way you get to where you're doing? So
usually the means ends isn't really applied with due process. It's more of an equal protection thing, and I don't want to confuse you more so. But the general gist is, and this is almost true, when we do abortion, we'll get to this more in detail, but if there is a fundamental right, the government loses. Right? If they're infringing a fundamental right, the government loses. If it's not fundamental, the government wins. So let me make this very clear, right?
Well, it seems like it would be helpful to do that.
But the court doesn't, so I don't want to confuse you more than necessary. If you want to, that's fine, but I don't want to confuse you more than necessary. Yes.
So this was the non-fundamental right that passed the rational basis.
What year was this case decided? What year was footnote 4? Ah, so you see, we're going ahistorical. The cases here are before footnote 4. When we get to Griswold, they'll try and make all this make sense. But this wouldn't really make sense because, again, this is Lochnerism. This is the courts saying that this violates a liberty interest. This wasn't a First Amendment case. You'll notice the Griswold court says, oh, these are First Amendment cases, right? Notice that? Lies. Lies. These were not First Amendment cases. I'll tell you why. Because the First Amendment had not been incorporated to the states yet. The reason why these could not have been First Amendment cases is in 1923, the First Amendment did not apply to the states yet. It's a lie to call it a First Amendment case, and Justice Black correctly calls them out in dissent. All right, so any more questions on Myers or Pierce? All right, so the next case is probably one of the hardest cases for me to teach this year. And I'm usually good at teaching a case objectively, but for this case, I signal a flag saying it's very hard for me to teach this case objectively because it's so terribly wrong in every conceivable fashion. This is the case of Buck versus Bell. Oh, you thought it was talking about Griswold. No. Buck v. Bell. This is probably the hardest, one of the top 5 hardest cases for me to teach as a professor. So the reason why this case is so hard to teach is because it's so terribly wrong. Okay, so what do we mean by that? Let me give you the background of this case, which is not in the opinion. The facts in the opinion are by Justice Holmes, and he basically accepts the rendition of facts provided by the government, which were not true. We discussed last week Loving versus Virginia. Remember that case? This was the case from Virginia where there was a law that prohibited interracial marriage. I remember this case? And I think I said, make a note about this 1924 Racial Integrity Act. Does anyone remember what else I said about that act? Eugenics. The same law in Virginia, which banned interracial marriage, also provided for the sterilization of feeble-minded persons. Think about that. The same brand of eugenics that wants to create the purity of the races also wants to eliminate, right? They want to eliminate bad people from the gene pool. This is not an accident. This was eugenics, which is a popular theory. It discusses in the book that Presidents Roosevelt, Taft, Wilson, Coolidge, Adolf Hitler, others all agree that this was a good way to go. Helen Keller, even for God's sake, she couldn't even see. So that one blows my mind. I still don't understand that. How she would want to actually been terminated, I suppose. Anyway, this is Carrie Buck. She was deemed by the state as feeble-minded. Why was she deemed by the state as feeble-minded? Because she had an illegitimate child out of wedlock. How did she have a child out of wedlock? She was raped by her uncle. Whoa, right? That fact would have been useful to the court, which described this, we tried to call it the promiscuous, feeble-minded harlot, right? She was raped. And that's why she had a so-called illegitimate child. Okay? This is Carrie Buck's mother, Emma. The state found that Emma was also promiscuous because she had Carrie Buck out of wedlock. So she's been married for 10 years at the time, but that fact wasn't important. Okay? This is Dr. Bell, who was the superintendent of the Virginia State Colony for Epileptics, which basically meant feeble-minded persons. This is the courthouse in Virginia where Buck got her, I'll call it a trial, put that in quotation marks, where she was heard. And this was the home for the epileptics and feeble-minded people in Virginia where she was sterilized following Buck v. Bell. Okay. This is the family tree of Carrie Buck. So one of the most jarring quotes in Supreme Court history came from the pen of Oliver Wendell Holmes. And by the way, I told you this before, but Oliver Wendell Holmes famously said, if my fellow citizens want to go to hell, I will help them get there. It's my job. He believed that. He believed that. In fact, he actually once wrote a letter to a colleague where he said it gave him great pleasure to write this decision. All this talk about Mr. Herbert Spencer's social statics and social Darwinism, and the biggest social Darwinist was in dissent in that case. It was Holmes himself. This says, most immediate blood kin of Carrie Buck showing illegitimacy and hereditary feeble-mindedness, right? So, everyone like familytree.com, whatever, right? This is the family tree. So you see levels 1, level 2, and level 3. Okay. So here we have Carrie Buck, and you can't see this, but it says F inside of her circle, which means feeble-minded. Okay. Carrie's mother is Emmy Buck, I just showed you a picture of, also feeble-minded. Okay? Carrie's daughter, Vivian, also with an F, feeble-minded. So there's this jarring sentence in this opinion. 3 generations of imbeciles are enough. 3 generations of imbeciles are enough. 1, 2, 3. He was being literal. He was being literal. That because Carrie Buck's mother was feeble-minded, she wasn't. Carrie Buck herself was feeble-minded, she wasn't. Carrie Buck's daughter was feeble-minded. We're talking about an infant here who was a few years old. Because they were all feeble-minded, that's enough. We need to rid the population of the gene pool, sterilize Carrie Buck. I'm sure once her daughter is of age, we can sterilize her too. Okay. This is what the 3 generation lines mean. When I show this picture, it becomes very, very clear how these people thought. Okay. So this is actually Dr. Hochland, who was a Virginia scientist. This is actually a commendation from the National Socialist Party of Germany. You might know there as the Nazis, who gave him an award for his breathtaking work on eugenics. In 1936 in Heidelberg, Germany was a little busy at that time, I suppose. Sorry, hitting on the Germans today. Sorry, Tiffany. But, you know, it's signed by, you know, the German government. Okay. Here is Buck later in life after she died. Let's talk a little about propaganda and eugenics. Okay. This is hard to read, but it says, some people are born to be a burden on the rest. Learn about heredity. You can help to keep these, help correct these conditions. Okay. This tree, which says eugenics is the self-direction of human evolution. And there was this genuine belief that through selective breeding, forget interracial breeding, my God, but through selective breeding, like the way you would do to a dog, and through sterilization, we can create a better human race. And this argument gained significant cachet in the early 20th century. If you went to any college campus, the presidents of Harvard, of Michigan, of Columbia, all these presidents of college said, this is social science. This is how we make our society better. I pause for a brief digression. Ever remember the footnote from Brown v. Board, which says, because social science tells us that segregation is bad, we can't have segregation? Think of a similar footnote just Holmes could have put into his opinion. Now, yes, every social scientist today tells us that eugenics is good. Think twice before you let you link constitutional rights to what scientists say. Not a very good idea. Because the same social scientist who said segregation is bad, 30 years earlier said eugenics is good. So think twice about that footnote. I always make a note of stopping there. Anyway, this is Justice Holmes, who had said 3 generations of imbeciles are enough. So here's Carrie Buck's daughter. Okay. How was it determined that an infant, you know, a few months old, was feeble-minded? How do you administer an IQ test to an infant? You don't. You know how they determine the daughter is feeble-minded? Ready for this? They put a coin in front of her face. They said, you know what? She didn't look at it. That means she's feeble-minded. They put a coin in front of her face, try and get her attention, and then baby just looked right past them. See her holding it up right there. I don't know what the babies look at. Does anyone know what babies look at? They do whatever they want. They're babies, right? They're babies. This was science, and they said it's in our estimation that the daughter was feeble-minded. Okay. There's it carries baby right there. 1924. By the way, in case you want to know, here's actually the daughter. She did pretty well as a B student. The entire coin test wasn't a very good measure of IQ. The daughter died at the age of 8 with some sort of intestinal disease, so her life wasn't very good either. Anyway, there's Buck later in life. She eventually got remarried. Okay, I'll go back to this later. Okay, so the case here reminds me a little bit of the lottery. Okay? Because Virginia established a very elaborate relation. Okay? The state didn't just say, you know what, we're going to sterilize you tomorrow. They created a process. Okay, what was this process? Well, first, the superintendent of this mental hospital says, it's my opinion that you should be sterilized, that your fallopian tube should be cut. Okay? That's the doctor who got the award from the Nazis. Okay? He decides that, in my scientific opinion, you should be sterilized. So what happens next? The superintendent presents this opinion to the board of the hospital, showing the facts. Remember the flow chart, the family tree? Showing facts about why the feeble-minded. Okay? At that point, a hearing is scheduled, and a lawyer is appointed for Carrie Buck. Do you know who that lawyer works for? The hospital. So basically, they appoint a lawyer for Carrie Buck, who works for the hospital. No evidence is presented on behalf of Carrie Buck. Nothing to suggest that she was raped or her mother was married or that this entire thing is freaking ridiculous, right? The entire trial was a sham. In every sense of the word, a sham. Okay? Then this hospital board says to Carrie Buck, hey, yeah, we agree you're feeble-minded, snip, snip, right? I'm being sarcastic on purpose because this is basically the essence of the process. They said, yeah, we'll have a hearing, bring your evidence with your fake lawyer, yeah, we'll listen to it, okay? Then it's appealed to the trial court in Virginia, and then it's appealed to the Virginia Court of Appeals. By the way, this is the same Virginia Court of Appeals which upheld the interracial marriage law. Remember that great quote where they said that the races of the earth and the different continents, the white, the black, the Malay, remember that, right? So that same court said, yeah, no problem here, this is fine. And the case goes to the Supreme Court. Yeah. Oh, they did. They thought this was the new wave of science. That this was going to make us. What was the vote in this case, Sarah? 8-1. The vote in this case was 8-1. Not even a recorded dissent. Justice Butler didn't write a dissent. I think he was quite ill at the time. Right? The vote in this case was 8-1. But you're exactly right. At the time, no one thought this was a big deal. But I want to discuss Holmes' opinion in a minute. Okay? So, say, Juan, procedurally, was there anything wrong with this process? Did the state establish an entire process before depriving someone of liberty interest? Wasn't there a process? Yeah, but they had a hearing, they had a trial, right? So they got their process, right? Remember we discussed last week the lottery, the thing where they all drew numbers from the thing and they got stoned to death? Reminds you of that, doesn't it? So what about the lottery made it so messed up, even though there was process? No, the process was fair. What was it about the lottery that made you so upset? Made me upset.
Well, chance.
It's not that it was chance. What was the underlying issue there? What was actually about that drove you crazy? Let me ask you this one, Juan. Would any amount of process ever justify stoning a woman to death? That's the issue. Is there any process that could ever justify cutting fallopian tubes? No, right? We're not talking about it as a punishment for a crime. Maybe if you're a sex offender, you're going to get castrated. I don't know. Like there may be some fringe cases, right? But could there ever be any process justify castration? This is why we discuss substantive due process. that even though she was given every procedural guarantee in the world, she had these trials and a lawyer and all this other garbage, right? The underlying law was unfair. The underlying law violated a liberty interest, or so we would think today, to Sarah's point. Back then, no one even seemed to care. Is there any process that could justify this castration of Carrie Buck? Okay. So Justice Holmes acknowledges. He says, look, he's like, look, if there's any sort of process argument, right? If there's any sort of process argument, she can make it. If the process's challenge is not fair, that's problematic, right? But Patrick, are there any process problems here according to the court? There are no process problems, right? So what is the attack on? It's not. Answer my question. If it's not procedural, what is the attack? Yes, right? It's not a challenge to the process, but to the substance of the law itself. And what is the substance of the law that's so problematic? Yeah. Yeah. It's on the substance of law itself, right? It's no process can ever justify, no circumstance can ever justify the castration of Carrie Buck. Okay? So, Mitchell, let me ask you this question. Is the court here applying what we might call a presumption of constitutionality or presumption of liberty? How would you describe the court's opinion here?
I would say they're on a presumption of constitutionality.
That's correct. Why?
Because they believe that there's nothing wrong with the procedure or that there's due process.
When I say a presumption of constitutionality, right? If you're applying a presumption of constitutionality, whose facts are you going to accept, the government's or the challengers? Whose rendition of facts do you prefer? The government's. Why?
It's just what the lower court based their decision off of.
Good. Justice Holmes basically defers entirely to the government here. He recites the government's rendition of facts. He doesn't mention that Carrie Buck was raped. That was in the record. He doesn't mention that her daughter was, tested by this idiotic coin test, right? That was in the record. The entire premise about this opinion is they basically defer to the government. If they want to go to hell, I'll help them get there. If they want to have this procedure, I will let them have it. Yes?
How did you get to the Supreme Court? Was it like with the same lawyer? Like, what? Who would take her to the Supreme Court?
I think by the time she got to the Supreme Court, she got a real lawyer. By the Virginia courts, I think she had whatever lawyer the state gave her, who was on the take. The entire issue, this was also a test case, because Virginia was one of the leaders in this form of eugenics laws, and they were trying to get a case to the Supreme Court. Subsequent to this, I think 30 states enacted similar laws, and every state basically modeled it after Virginia. So this was not limited to Virginia. Almost every state in the union had a similar law where they would sterilize people they deemed feeble-minded. Scary. This went on until the 1970s. Quietly, but this went on until the 1970s, okay? This is not as old as you think it is. In fact, in North Carolina, just last 2 or 3 years, the state found a way to compensate people who were still alive who had their who had been castrated. Okay. So Holmes' opinion is like this. He's like, listen, right? We can call upon citizens for their lives. We have the draft. If we can call on a citizen to die in war, then shouldn't we be able to do something lesser than that, of allowing us to sterilize them? Okay? Yeah, it would be strange if we can ask them to die in war, but not do this. We can ask for this sort of sacrifice. This, of course, presumes that the compelling interest of national security in the war is on the same level as eugenics. But at the time, cutting edge science, people said, yes, this is necessary to survival of our race. We need to have these super ubermenschen, right? Supermen, racial purity, who can push forward. Justice Holmes writes, it's better to sterilize these women now than to let their offspring be executed later, or let them starve for imbecility. Society can prevent these manifestly unfit from continuing their kind. In other words, it's better to stop them in utero before they're even conceived than allow them to be born and create crime and other stuff. He cites another case, Jacobson versus Massachusetts. We've discussed before. This said that you can force vaccinate someone. And this is not the Jenny McCarthy anti-vaxxer crap you have today. And I don't say that lightly, but that's crap. This is a case where you had vaccinations that would kill people. They weren't very safe. But the court held that in the smallpox outbreak, the state could force you to get vaccinated. So Holmes says, if we can force people to get vaccinated, why can't we force them to take out their fallopian tubes? What's the big deal? You may see a big deal. Okay? And again, we have the canonical quote, 3 generations of imbeciles is enough. Okay. So in other words, whenever the government can think of any good reason why they want to do something, it's not for the courts to second guess and inject their own values. If society wants to do this, let them change the branches. Let them lift the elected branches. Sarah? Yes. Puerto Ricans, blacks, you name it. Yeah, I mean, yeah, it was a mess. This was not limited to people feeble-minded. Basically, it was done by race. You can concoct any reason why someone's feeble-minded. Yeah, this is a very dark period in our history, and it's dark for the reasons that Justice Holmes explains. If this is what society wants to do, let them do it. Let them do it. All right, so any questions on Buck v. Bell? It's a disturbing opinion, which I should add has never been overruled. It's actually still good law. And when you read Roe v. Wade for class next year, I'll give a gold star if anyone can find it. It's cited in Roe. Favorably, too. Yes. Yep. 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 Yeah, it's often said that that Americans invented eugenics, but the Nazis perfected it. That's often how it's described.
So when you say Roe v. Wade, you're saying that's for abortion?
Look, when you read Roe, look an eye for Buck v. Bell. It's favorably cited.
Is that the connection you're trying to say?
I'm not going to give it away, but read Roe and you'll see it. It'll take 20 minutes to explain it. But just when you read Roe, keep an eye for Buck v. Bell. It's there, I promise. All right, any other questions on Buck v. Bell? It's a disturbing case which seems totally at odds with how courts say think about individual liberty, but it's still on the books, still good law. All right. The last case we'll discuss today is called Griswold versus Connecticut. And what's important to remember about Griswold is the time in which it was decided. For the past 20 years at this point, the court had been saying over and over again, we're not about Lochner. We're not about Lochner. Unless there's some right that's in the Bill of Rights or affects the political process, we are not going to second guess the wisdom of the legislature, right? We are not going to do it. But the problem with that theory is that it doesn't do much for the sexual revolution. Birth control, abortion, various acts of expression, sodomy, you name it. If we limit our liberty interests to political process rights, how does it get us to abortion? I want you to realize and recognize Griswold as what it is, a conduit to abortion. That's all that it was. Okay? The opinion in Griswold, if you notice, you read it carefully, it says over and over again that this is a right for contraceptives to married couples. You notice I kept saying it over and over again, contraceptives for married couples? That drops out very quickly. This entire charade of making this limited to married couples was just a stepping stone. You know, at the Supreme Court, Planned Parenthood, others insisted, no, this is only for married couples. We're not talking about anything outside of married couples. That dropped out very quickly. So what you have to understand, this was basically a conduit to get to Roe v. Wade, and a necessary one. So the opinion itself is actually fairly short. And it's maddeningly obtuse. All right? So here we have Estelle Griswold. She was the head of the Planned Parenthood of New Haven, Connecticut, right near Yale Law School. Here she is in front of her store. By the way, Planned Parenthood was founded by a woman named Margaret Sanger, who was a very prominent eugenicist, and she's mentioned in the reading. So Planned Parenthood was actually found as a way to limit population growth for certain minorities. And if you want, you can Google that, but there is a very sordid history that's there. Go Google Margaret Sanger if you're interested. The opinion in Griswold by Justice Douglas is maddening. I'm sure you're reading this like, what the heck is the test, right? What is the constitutional right? Is it the 14th Amendment? Is it the 9th Amendment? Is it this? Is that? So, the first thing you have to know about Griswold is that the court says, we're not Lochner. I promise. I swear to God. We are not Lochner. We're not Lochner. Right? Why? Because Lochner justifies economic liberty, which thwarts the progressive state. They say, we are not Lochner. We are not, inserting our judgment. We're not second-guessing the wisdom of the legislature. That's not what we're doing. We're not doing that. Promise us. Does anyone believe it? Of course not. Right? The analysis they use, which is based on these liberty interests, is extremely very similar to what was done in Lochner. But rather than protecting economic right, protecting some sort of nebulous property right. Okay? So first they say, this isn't Lochner. They recharacterize Pierce v. Society of Sisters and Meyer v. Nebraska as First Amendment cases, right? These cases which discuss family privacy and family autonomy are very useful, right? If I can direct the upbringing of my child, then why can't I direct how my husband and wife, arrange contraceptives? So those precedents were useful, but that to recast them, not as substantive due process cases, but Meyer and Pierce became First Amendment cases. Huzzah, right? First Amendment cases. Lies, right? These were not First Amendment cases because First Amendment had not even been incorporated to the states yet. So to get there, they first have to chop away all those precedents, right, about Lochner. Those don't apply here. And then say, well, we're going to keep these other Lochner cases like Meyer and Pierce by saying the First Amendment. So now they say we have this general sense that we have these liberty interests, one of which is this right to privacy. And where does this right to privacy come from? In one of the most frustrating sentences in Supreme Court history, we learn that these rights actually come from penumbras. What is a penumbra, you may ask? Well, I have a diagram. Oh, Sarah, what's a penumbra?
Sorry, I had a lot of
Please, yeah, please, enlighten us. No pun intended. Enlighten us.
Like, if you have an umbrella of rules, you would think about the penumbra as like the gray area outside of that, umbrella that are implied by what that umbrella covers.
Good, okay, good. So let me give you a mini astronomy lesson. That's very good, okay? Everyone knows, right, that when you look up in the night sky and you look at the moon is glowing. Everyone know that, right? I hope you should know the moon does not generate its own light. Everyone with me so far, okay? I assume nothing in this class. The reason why the moon is illuminated is because this thing called the sun. And what happens is the sun shoots this ray through the earth, and the light escapes, and it basically glows the moon, makes the moon glow. This is called the umbra, okay? But what about this kind of region outside? This kind of, Sarah said gray, which is a good word, this penumbra region, right? Where it's kind of light, kind of not, maybe a zone of twilight just to screw up even more, right? This zone of twilight outside. So we have our rights and we have penumbras to rights. So in the same way we have this like light and then you have this, stuff around it, we have these rights. So what does Justice Douglas say? Well, we have a First Amendment right to assemble. Well, that means we also have a right to freely associate with who we wish. Okay? The Third Amendment. Notice he skips a second. No Second Amendments. Forget that. God, I mean, of all individual rights to talk about, the Second Amendment's a good one. The Third Amendment, right? Well, you prohibit quartering of soldiers in the house. That means you have privacy. You keep soldiers out of your house. You have the Fourth Amendment, right to be secure in your possessions. Well, that means privacy too. You have the Fifth Amendment, no self-incrimination. That means you have a privacy interest against yourself, that you can't be forced to testify against yourself. And it goes on, right? Basically, they're making stuff up. Okay, I don't mean to put a point in this. I'm expressing no judgment on birth control laws. This has nothing to do with the substance. They're making stuff up, and this opinion is universally ridiculed as silly. Okay, and you have to quote me. Go Google it. This idea that you have a First Amendment right and a Third Amendment right and a Fourth Amendment right and a Fifth Amendment right, and they all come together in this hazy penumbra and shoot out these emanations and create a zone of privacy. That's the holding of Griswold. And don't ask me to repeat that, because that's it. You have these rights which maybe have something to do with privacy, maybe don't, but we put them all together. This creates a zone of privacy for married couples, and the state can't ban birth control. What is the rule of law here? I don't know. Right? What is the holding? Penumbras. That's basically the holding of the case. Penumbras. As a result, the state can't criminalize sodomy. Sodomy. Can't hear myself. Birth control. That's it. That's it. The opinion is very short. It's only a couple pages long for the majority. All right. So, any questions on the majority opinion? And I don't mean to be glib, but it's uncommonly silly of an opinion. And it was a unanimous vote. Oh no, 7-2, I think. Okay. The more interesting debates come in the concurring opinions and the dissents. So the lead concurring opinion is by Justice Goldberg, who served very briefly. Actually, Justice Breyer clerked for him. Justice Goldberg had opinion concerning the Ninth Amendment. And we've discussed the Ninth Amendment a few times before, but I'll discuss it again here. Ninth Amendment says, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage other rights retained by the people. All right. So, Madison, let me ask you this question. The Ninth Amendment, right? It's in the Bill of Rights, right? Does the Bill of Rights apply against the state or the federal government? Federal government. Who passed the contraceptive law here, Connecticut or the United States? Would the Ninth Amendment protect anything concerning the state of Connecticut? That's right. No, you're right. The provisions of the Bill of Rights only apply against the federal government unless a court held otherwise. The Ninth Amendment does not apply to Connecticut. I said it again. The Ninth Amendment does not apply to the states. So let me disabuse you of this notion now. The court's opinion for Justice Goldberg was not based on the Ninth Amendment. He would let you think that, but it can't be because the Ninth Amendment has not been incorporated. I remember thinking it's also, oh yeah, great, Ninth Amendment, awesome. It doesn't apply to the states. Okay? Right, yeah, you would think otherwise if you read it quickly. But why is the Ninth Amendment relevant? What is Goldberg trying to show? Well, it says here, the enumeration of the Constitution of certain rights shall not be construed to deny or disparage other rights retained by the people. Okay? So Daniel, remember I said before in footnote 4, what did footnote 4 do to our rights? How did it divide them? So what did it say there? What happened to the rights that were listed in the Bill of Rights? Were those fundamental? What about the rights that were not listed in the Bill of Rights? Those fundamental or non-fundamental? Exactly. You see this here, right? Footnote 4 divided our rights into fundamental, non-fundamental rights. Rights that are in the Bill of Rights are fundamental. Everything else is unfundamental. Right? Daniel, How the heck do you reconcile footnote 4 with the Ninth Amendment? Doesn't the Ninth Amendment say just because something's not listed doesn't mean it's just as important?
Well, that's actually kind of difficult. I think if you were to incorporate that into states, then that would really, it would make it really difficult. It would kind of like take away this power.
Okay. Footnote 4 and the Ninth Amendment are in tension. Footnote 4 tries to say, here are some important rights, and here are these other rights we don't care about. That's the exact opposite. The exact opposite of what the Ninth Amendment says. In fact, they discuss the history of the Ninth Amendment. It was designed to protect this exact idea, that the recognition of certain rights shall not be used to deny or disparage other rights. Just because we list these 10 things in the Bill of Rights doesn't mean others are not as important. So what Justice Goldberg's trying to say is that we've been saying for a long time that there are certain rights which aren't clearly defined in the Constitution. You can call them penumbras, call them whatever you want. But the mere fact that something's not clearly listed in the Constitution does not mean it doesn't exist. Questions on that? Right? So how do we know? How do we know if a right is fundamental? And this is where we pivot from footnote 4. Footnote 4 said the rights are fundamental are the Bill of Rights and political process. But if you notice, they're not so limited here. We now have this right of privacy, right? We have moved beyond political process theory into this ever-expanding notion of evolving rights. Rights which suit the needs of today. The living Constitution is born. Okay? So at the same time as setting aside Lochner and getting economic liberty, the Supreme Court starts to say, all right, we need this privacy thing for abortion. Let's start here. Right? Let's get our foot in the door. And he discusses right to privacy. Okay? So everyone with me so far. Okay? So basically, they're not quite making stuff up, but it's awfully close to it. But there's a point raised in Justice Goldberg's dissent which is very important. He said, what happens if the state passed a law saying that after a woman has 2 children, she'll be sterilized? Would that law be constitutional? He says, of course not, because of the zone of privacy. Right? The state can't intrude in this privacy. Ask yourself, what would you have written in Buck v. Bell to say the law was unconstitutional? Right? What was the liberty interest infringed upon when they cut Carrie Buck's fallopian tubes? Was it a right of privacy? What was it? So it's very easy to mock the opinion in Griswold, and very easy to criticize the opinion in Buck. But you eventually need to say you can't have one without the other, right? If you want to have Carrie Buck's fallopian tubes not cut, you need to recognize some sort of liberty interest, called privacy, whatever. And if that liberty interest exists, does it also carry over to contraceptives? Right? So although the opinion of the court is somewhat fanciful and ridiculous on its terms, it basically dances around probably what most people think is the right answer, that you have a certain interest that government cannot intrude without a really good reason. Right? What's the government's reason here for banning contraceptives? They want to decrease adultery. They want to limit adultery. Because if people can have contraceptives, they'll go have affairs. That's the thinking, right? If people have condoms, they can go have affairs, right? Because they don't have to worry about children, illegitimacy. The court says, yes, the state has a valid interest in protecting against adultery. Imagine that. The state said laws banning adultery are valid. But this law is too broad. It bans it for couples in marriage, and they have that right. Again, they keep saying marriage, marriage, marriage. That drops out next week. That won't even matter by the next class. But it's all about marriage. Okay? The dissents by Justice Black and Justice Stewart make the point very clearly that this is Lochner. No matter what you want to call it, the court is second-guessing its wisdom. I'm sorry, second-guessing the wisdom of the legislature. The court is deciding that we will decide, not the people. By the way, this contraceptive law was never enforced. It had been in the books for over almost 100 years. It was never enforced. Griswold basically asked to be arrested. They basically set up this case where they would arrest her deliberately so she can get to court. Similar with Lawrence v. Texas, the sodomy law had never really been enforced. And basically they insisted that they actually be charged with sodomy to get this to court. I'll tell you the story in a few weeks. So you have a law that was never enforced, that the Connecticut legislature was in the process of repealing. They were trying to repeal this law at the very time. But now the court took that decision out of the elected branches. Okay? And the dissenter said we should not be inventing constitutional rights. Let's stick to footnote 4, right? Let's stick to footnote 4. Bill of Rights and political process, nothing else. But here, fundamental rights begin to expand, and now the right to privacy is among these fundamental rights. Okay. Questions? Yes, ma'am.
I just have a comment on Buckley Bell.
Yes.
So I found online, it was in Huffington Post and LA Times, that the Center for Investigative Reporting found that in California they're still sterilizing, they still sterilize inmates in 2013 without their full consent, when the legislator passed a bill.
Yeah, I read about that. There was a question about what kind of consent they were provided. But
It says sterilize without proper state authorization and doesn't have tubal ligation procedures were performed without full consent of the inmates.
yeah, I mean, I read about that a little bit. I think that there was a question of how much consent was provided, but it's still an issue. All right, other questions? All right, see you all on Thursday.